Good morning, everybody. Well, Mr. Donoghue,
Good morning.
pleasure to meet you this morning. So the topic today at hand is compliance issues and other issues related to corporate transactions. And obviously there are a few that have gotten a lot of headlines recently. So maybe we'll start with the basics. When does the Justice Department get involved and the other regulators get involved in the corporate transaction review process? And how does the U.S. Attorney's Office interact with Main Justice Antitrust Division?
So there are a variety of ways that the Justice Department or our regulator partners get involved in reviewing corporate transactions. Obviously, there are some, the larger transactions that under Hart-Scott-Rodino require prior approval of the department and typically the FTC. So those will get reported in to the department and our partners in the regular course of doing an M&A transaction. And you're probably familiar with, if you've been in these companies or provided assistance as outside counsel, how that process works. And it's basically hopefully just a two-step phase where you have the initial phase and certain notifications are made. There's usually a request for documents and other information so that the department and the FTC can look at the transaction to determine whether or not it's going to have an impact on competitiveness on the market, whether there are going to be concentration concerns. And there are some other things that go into that as well that have changed a little bit over time. But there are also a variety of other things, that we're not limited to HSR reviews. Certainly businesses have the opportunity to go to the Antitrust Division, in our case at the Justice Department, to ask for business reviews, and there's a formal process for that. If a business has concerns about whether a transaction might cause them any issues down the road, it is prudent to do that, and that is very much a formalized process that's been in place for decades now. So could get involved through that process as well. And there were a number of others that might come in from different avenues. Certainly national security is a major focus today, as it has been for the department and the government for a long time. And there are transactions that could come to our attention that might draw some concerns about national security and related issues. So there are a variety of ways that these transactions could come to the attention of the department or our regulators that we work with typically. In terms of the relationship between the Antitrust Division and the U.S. Attorney's offices, I think we've got a great working relationship. Of course, antitrust is a long-established and well-developed practice area. And it requires a certain expertise, and they really have that expertise. The Antitrust Division sits in Washington. They have a cadre of really well-trained prosecutors, investigators, and analysts who can look at transactions. But it really runs the full spectrum. They have criminal enforcement authority, civil enforcement authority, as we do in the U.S. Attorney's offices. There are times that we pair up on things. If you go to perhaps one end of the spectrum, look at bid rigging cases. You might have a local bid rigging case, right? That's the kind of thing that the U.S. Attorney's Office may work either on its own or in conjunction with antitrust. But as far as reviewing corporate transactions, it's mainly their expertise in Washington that is the way that the department comes into play to look at transactions to determine whether or not they raise concerns either on free and fair market competition issues or national security or other issues.
Right, and so what are some of the other, obviously market concentration is the first thing people think about when they think of antitrust.
Yeah.
And national security, I think, again, some recent examples, that comes second. What are some of the other issues? Are there data privacy issues? Are there IP issues that U.S. attorneys would look at?
Yeah, absolutely. I mean, those are sort of primary for the companies, secondary for the regulators. But we do want to look at whether or not the entity that emerges from this transaction will actually be operating in accordance with the law and the requirements. And certainly if you are a corporate leader or advising and assisting corporate leaders, you have all sorts of concerns about IP, data privacy. We've got GDPR now in effect. We have lots of different data privacy regulations and significant consequences, obviously, in the EU and elsewhere. So data breaches are and should be a major concern for every corporate leader. That's a concern. It's secondary for us because obviously the implications there are primarily on the corporation. However, we do have concerns about whether or not the entity that emerges from the transaction is going to meet all its requirements. So we will look at things like data privacy, IP, and because the market is so dynamic right now because of, particularly in the technology field, things are moving so rapidly. You need to look ahead a little bit, right? This is a predictive exercise to begin with because you have to look at if this transaction goes forward, how does that affect the market? And that's never a simple undertaking, but the experts are pretty good at doing that. What's complicated it more is that now the technology is developing so rapidly that you have to look not only at what would this do to the market right now and in the foreseeable future, but what are these different entities developing? What are they likely to develop in the next few years? A lot of companies have, Horizon 2, Horizon 3 objectives. And if you look at those and say, well, this transaction may not raise immediate competition concerns or immediate national security concerns, but 3 or 5 years down the road, depending on what they're developing, what areas they're moving into, is it then at that point going to create concerns? So you have to be able to look a little bit further down the road, given the rapid development of technology.
Okay. So you mentioned that there have been some changes in the way things are looked at by the U.S. attorneys. You've worked in the Justice Department in multiple administrations. Can you compare how the Trump administration's priorities might differ from the Obama administration's? And, how do companies kind of plan for those kind of changes?
Right. Yeah. So, you have to recognize, as I said a little bit earlier, that antitrust certainly is a long-established, well-developed practice area, right, that is focused on maintaining and fostering free and fair markets. And so those fundamentals don't change from one administration to the next, but there are important distinctions, I think. So if you want to look at the current administration and how it approaches some of these things, certainly I think that the current administration probably has a greater appreciation for how business affects national security and how the government, regulators and the department and others affect business, right? So if the business of America is business, it's very important that the department understand how our actions as the government impact business. So I think they do have a greater appreciation for that. In some way, I'm perhaps an example of that because it's not typical to have someone who is an in-house counsel be the U.S. attorney, right? That's just not the normal path. So I'm very lucky to do that. I'm very lucky to have that opportunity. But I think, as I said in the introduction, I was a career prosecutor. I left in 2011. I went to a major software company and headed litigation for about 6 years. But it gave me a great opportunity to look at how a publicly traded company operates on a day-to-day basis, how it engages in worldwide transactions, and what some of the challenges are. And when I was being considered for U.S. Attorney, I interviewed with then Attorney General Sessions. And the first 4 or 5 questions he asked me were about the business. What does your business do? What markets are you in? What are you trying to do? What do you do on a day-to-day basis in terms of interacting with business leaders and leaders around the world that are running our subsidiaries? So the fact that the Attorney General was keyed into that tells you something about, I think, the department's sensitivity. It's not deference, but it's sensitivity to the impact that government has on business. So that's part of it that I think is an important distinction. Another one is, as I said, the understanding that business affects national security. National security has long been the department's priority. It has for many generations across different administrations. However, I think there's a greater understanding now about how business affects national security. Because the reality is, at the end of the day, if you're looking long-term, business transactions can have as much of an impact on our national security as planes and tanks. If you think about this, particularly so now, where we're moving into a 5G world, right? And we are very much, in the sense, rewiring the world's infrastructure. And questions about who will have access to that infrastructure, who have control of that infrastructure, who will be able to manipulate it if they have bad intent, those are major concerns, and those are national security concerns for the United States. And so I think this administration has moved those concerns to the forefront, looking a little bit further down the road about how we can best serve our national security.
Okay. So just changing the topic a little bit, you mentioned you worked in-house counsel for several years before coming back to the Justice Department, and you were involved in some transactions there.
Yep.
So were there any regulatory questions or other issues that came up that surprised you or where you thought, this doesn't work right, there are better ways to look at these issues?
Sure. Look, we were operating in, I think, 45 countries when I was at the company, and there were lots of regulatory interactions, routine stuff, and sometimes not routine stuff, right? So there were times when we would have interactions, we would get inquiries, and you would realize that the regulator doesn't really understand our business, which is certainly understandable, right? There's no way that a regulator, even a U.S. government regulator, can really know your business and how you fit into the industry. So a lot of it was educating them, I think. They had legitimate concerns and questions, virtually all of which could be answered pretty easily in a reasonable time frame. But I found it useful when dealing with regulators, whether in the U.S. or around the world, to say, okay, up front, this is who we are. This is what we do. This is what we're trying to do if it's a transaction that's proposed, and explain to them how we fit into the bigger picture. So it wasn't so much a matter of being surprised by a regulator's request. It was just recognizing that regulators are not experts in your business, and it's best for everyone if they have a real working understanding of what you do and how you fit into the bigger picture.
Okay. Now, moving on to the international aspect of this. Let's say you're a company, you're doing business around the world, you want to enter into a transaction. How should a business balance all of the concerns of competition regulators around the world that might have different emphasis?
Yeah, it's difficult, right? As we see globalization, as we see technology rapidly advancing, it becomes a much more complex undertaking, right? Whereas years ago, you would do your transaction, you would report it and go through a fairly predictable process. We now have a situation where there are more than 50 or so competition agencies around the world, and that deal that perhaps once upon a time only had to be approved in the United States or maybe Europe now has to be approved in Brazil and India and elsewhere, right? And those approaches, the procedures are very different from one jurisdiction to the next. But I would say there's improvement on that front because there are concerted efforts to bring some sort of uniformity to competition agency review. So my colleagues in the Antitrust Division have really taken the lead on this from the department perspective. You have the International Competition Network, which has provided some guidance over time. Now there is something, I believe it's called the Framework for Competition Agency Procedures, that is proposed and agencies are signing on to now, and there'll be some more movement on that front. But the effort with the CAP initiative is to bring some transparency and some predictability to this process when you're trying to do a transaction that covers all these jurisdictions, right? And as you know, business wants predictability. They can plan for just about anything as long as they have some real sense of what's coming. So in terms of timing, what would be required, and whether or not they can accurately predict whether a transaction will be approved at the end of the day is very important. And I think that our antitrust partners, FTC partners, and others are working toward doing that.
Right. And so maybe we talked a bit about the relationship between U.S. attorneys and Main Justice. Where does the FTC come in and other federal regulators and even state regulators that might be looking at these transactions?
Yeah, absolutely. It's true. State regulators, particularly in New York, right, more and more are part of this discussion and part of the process. So it's very important. Certainly we take a one-team approach here. The government has a lot of different moving parts, but it's one government. We're one entity, and we have to take one position. We rely heavily on the FTC for their expertise, just as we rely heavily on, say, the SEC and other key regulators that we work with. So we have our part, they have their part. But this is sort of a well-worn path, right? The department and FTC, the department and SEC, whoever it may be, even the state regulators, we work together on a day-to-day basis. We may have a slightly different focus, but these are well-established partnerships, similar to the partnerships between the U.S. Attorney's Office and Main Justice, the Antitrust Division, in this case. So they have different roles, but it's all one team.
Mm-hmm. And you mentioned the SEC. Insider trading was a major focus of several U.S. attorneys. And corporate transactions can be a ripe area for that kind of activity. At what point would U.S. attorneys or the SEC kind of perk their eyes up and look for potentially shady trading activity?
Is this one of these questions where you say, how far can I go over the speed limit before I get pulled over?
Yeah.
You know, with us? Yeah. So I would say that it is interesting, right? Because the vast majority of insider trading cases I've seen as a prosecutor, the amount obtained is pretty modest, and the results are catastrophic, right, for anyone involved. And it amazes me that people do these things thinking that it will not come to the surface, right? So if you look at, I remember the first time I was involved in an acquisition of a publicly traded company, right? And we went through the process, and we got our approvals, and it all worked fine. And then immediately after the deal closed, we got a very routine request from a regulator that said, we'd like to know everyone who had knowledge of the transaction prior to it becoming public. And so we did what we should have done along the way. We had a list that we could provide, and they took that list and they went out and they looked at not just did those individuals trade, because you probably have to be idiotic to do that, but did their neighbors trade? Did their brother-in-law trade? And people don't fully appreciate how easy it is in this age to tie people together, right? So in that process, not so much the prosecutors, at least initially, but the regulators will look at who traded in this publicly owned company prior to the announcement of the acquisition. And if there are people who have never bought that stock before and are buying it, or who have bought it and now buying a lot more of it, that raises questions. And then we'll look at that to see whether or not they can tie that person back to someone who had inside knowledge. So it amazes me how often people are surprised when a prosecutor, an FBI agent, a regulator shows up and says, hey, we'd like to talk to you about your brother-in-law who bought a lot of stock right before this transaction was announced. So, it is very difficult to escape scrutiny these days, and I would just caution people that you're best off following the rules.
Okay. And on national security, you mentioned that the Trump administration has put more focus on it than had been before, and looking farther down the road, are there instances where maybe the competition concerns and the national security concerns might come into conflict, and how would law enforcement and regulators handle that? Yeah.
So and I certainly don't want to downplay the emphasis of prior administrations' national security. It's been a priority for a long time, but I do think currently there's a better understanding of how business developments, business transactions affect national security, perhaps even down the road a little bit, right? So there is more of an emphasis on that. I think that it's not so much that they come into conflict, right? You're going to look from an antitrust perspective. You're going to look at whether or not this transaction is going to affect free and fair markets, whether there's going to be an undue concentration. But in addition to that, you need to look at the national security implications. So there may be a situation where you say, we're not so concerned about the competition aspects, but there are national security concerns. And those manifest both within the antitrust process and the review process and beyond that, right? So as I said, we're moving to a 5G world. We do not want to be in a situation where foreign adversaries with bad intent are in a position to control parts of our key government and societal infrastructure. So those things definitely do come into play. They are a concern. I think they're a heightened concern. And I think it's good that there's a lot of discussion about this, because business leaders, government leaders, but even just the general public seems to have a greater awareness of the risk that is posed by this sort of concentration of technology and power and the ability to use that for purposes that we as a society would not want that power used for.
Right. And you mentioned 5G and tech. Are there other, does law enforcement, does the Antitrust Division, do they look at different industries differently? Are there some industries that get more scrutiny than others?
Yeah, I think that's naturally the case, right? You have certain industries that are heavily regulated on the federal level, banking, communications, et cetera, right? Well, why are they heavily regulated? They're heavily regulated because they are an important part of our societal and economic infrastructure, right? We can't have them implode. And so I think naturally those industries will draw greater scrutiny just as they draw greater regulation. If you look at some of our partners, like state partners, they regulate similar but different things, right? So if you have a housing issue, right, that's more likely to be regulated by state authorities.
Right.
And they may have a concern there that is not as much of a concern for us. So different industries, sure, will draw different levels of scrutiny. Certainly anything in the communications field, data processing field, anything that touches on national security, defense contractors, obviously. These are all things that raise greater concerns than some other industries might.
Okay. And so when you came back to the Justice Department to be the U.S. Attorney for Brooklyn and Queens, what did you bring back from private practice with you that you're using in your reviews?
Yeah, I think I've just brought a more informed perspective. As I said, unusual to have someone who's in-house and sitting there sort of day in, day out trying to help run and manage a company to come back and sit behind the desk. I wish that I'd had that experience before I was a line assistant, when I was looking at white-collar cases and trying to imagine what that conversation was in the boardroom, what that conversation was between finance and internal audit or between compliance and legal, and what were they up to, because you have these organizations full of people. And you're trying to understand, and as a prosecutor, I think, recreate in your own mind from documents or whatever evidence is available, what they were really up to. Were people really up to no good here? Or was this simply an oversight? Was it a misstep? Was it just something that happens in the course of business? And I think that my experience living that for 6+ years in the corporate environment has given me a much better ability to think through what was probably going on at the time. We tend as prosecutors to focus in on our issue and to think that's what was going on. That was the priority for the company. But the reality is, any day in any company of any size, there are a million things going on. And there are a lot of other concerns. And you have to understand how this issue, these discussions kind of fit into the larger picture.
Okay. So you have a room full of people here who are involved in corporate transactions, who are involved in managing risk. What are 2 or 3 things that you would say to them to look out for when you're engaging in the transactions process?
Well, certainly in the M&A process, be careful of what you're buying, right? Know what you're buying. The due diligence in the acquisition process is incredibly important, because you buy all the good and all the bad, and you may well be buying liability. And so one of the things that the department looks at and our regulatory partners look at is, what was your due diligence like? Were you really looking? Were you kicking the tires? Were you looking under the hood to see what was there? Because you don't want to buy this acquisition and think it fills a nice hole in your portfolio and then find out that they have been violating sanctions regimes, for instance, for the last 5 years. And now, you've bought this little company with their nice technology, but you've also bought yourself potentially a disclosure to the department saying, we have acquired this company. We realize that they've been selling technology illegally to adversaries for years. So you certainly need to look at that. Broader picture, I would say, make sure that you as the legal department have a voice in your company, and that you're actually part of the decision-making process. Because at the end of the day, whether it's the department or regulators who come in, we're going to look at what role the lawyers played. And were the lawyers really part of the company, or were they sort of an appendage that was kept out on the far end that was there just to say, we review contracts and we have lawyers look at things. So it's an important aspect that the legal department, the general counsel, really be at the table and have a voice in the company. So
when things go wrong, can you usually trace it back to either a problem with due diligence or a problem with the lawyers not being consulted adequately?
More often than not, yes, or other guardrails and gatekeepers like finance, internal audit, compliance, those folks being sort of kept out, right? That's where we see problems come up, and that's a red flag for us. If we see people avoiding compliance, if we see people avoiding internal mechanisms that are designed to keep the company ethical and on track, that's a real red flag for prosecutors.
Okay.
Mr. Donoghue, we are in a room full of lawyers, so there have been some questions from our audience. I've got one here that asks you if you can comment on document requests from U.S. regulators and courts that may require a U.S. multinational company to break the law of another country to provide the information.
Yeah, so this is one of the issues that I think the current administration is a little bit more sensitive to, and just not the administrations aside, the department is becoming more sensitive to, because now you do have all these privacy regimes around the world, GDPR and elsewhere. We don't want companies to break the law. We don't want you to break the law in our jurisdiction. We don't want you to break the law anywhere else. So we need to understand from you, the company, what the limitations are. There's a tendency to exaggerate them, and I certainly understand that companies want to err on the side of caution, particularly when it comes to data privacy. But we're not experts in the data privacy regimes around the world either. So if we make a request and you cannot satisfy that request because of foreign limitations on what the company can or cannot do, explain that to us and we'll have that discussion, and we will not ask you to break the law.
And then just one more. We had a couple questions that came in related to the global nature of transactions, all around kind of CFIUS. And one of the questions that we got was that as of August, CFIUS foreign investments rules were amended and apply to a broader range of transactions and related entities. And so the question that we got was whether there's a link potentially between foreign investment review and U.S. attorneys' offices. For instance, is it possible that information communicated in a CFIUS process would convert at all to a criminal investigation, either during the review or afterward?
So the CFIUS review is very important, and I think the extension and the broadening of that review process is part of the recognition that business plays into national security, right? We need to know who owns what and what they could potentially do with it. I don't know the specifics of how, I'm trying to think back to my own experience, whether we ever had an instance where there was a CFIUS review and then someone took that information and said, hey, U.S. Attorney's Office, you ought to look at this. I don't recall that ever happening. I can't say it's never happened.
Right.
It certainly could happen once the information is with the government. It's with the government. But I don't think that it's prudent for companies to, in the back of their minds when they're trying to do a satisfied document request for a CFIUS review, to hold back anything because there are concerns about whether it makes its way to the Justice Department.
Okay. Well, thank you very much, Richard and Evan, for the great conversation.
Great.
All right.
Yeah.
Thank you. I appreciate it.